Ready, start. The contention was that the acquiring bank deducts the merchant discount and pays the balance to the merchant establishment. Full stop. The discount so borne by the merchant establishment results in income, the beneficiaries being the respondent and the acquiring bank. Full stop. The amount due to the issuing bank is settled by retention, that is, the card association debits the account of the issuing bank and disperses the same to the acquiring bank. Full stop. Payment to the card association is made separately by the issuing bank and the acquiring bank. Full stop. There is contractual relationship between the merchant establishment and the acquiring bank. Full stop. The issuing bank is not engaged in any service to the acquiring bank, and the portion of the fee retained by the assessee is not in respect of any service being provided by the assessee to the acquiring bank. Full stop. There is no service provider and service recipient relation between the issuing bank and acquiring bank. Full stop. They are participants in the credit card transactions. Full stop. For the service rendered by the acquiring bank to the merchant establishment, comma, the acquiring bank pays service tax on the gross consideration. Full stop. The disbursements made between the assessee and acquiring bank are not for any service provided by the assessee to the acquiring bank. Full stop. The acquiring bank does not hire the assessee to provide any service. Full stop. The interchange fee is not a consideration for any service. Full stop. The interchange fee is nothing but a portion of the service tax paid merchant discount and is not a separate consideration paid to the assessee in lieu of any service. Full stop. The perusal of Section 67 of the Act makes it clear that service tax is applicable on the gross amount charged by the service provider for a consideration received in monetary terms in relation to the provision of services. Full stop. The value chargeable to service tax is by the mandate of law required to be restricted only to the consideration for the service rendered, and no amount beyond this can legally be charged to service tax. Full stop. The consideration for the provision of credit card services is recovered by the acquiring bank from the merchant establishment, and the portion of the same is in respect of service provided by the assessee. Full stop. That therefore, comma, the gross amount charged for the credit card services is the merchant discount, which will form the basis for the levy of service tax in terms of Section 67. Full stop. All activities are undertaken by the participants to support a transaction where a merchant establishment is able to accept a payment from a credit card holder through the modality of credit cards. Full stop. The gross value of the service rendered, comma, having suffered service tax, comma, the so cause notices were impugned. Full stop. There is reference to case law in support of the same. Full stop. Only the value which has a nexus with the services rendered was liable to subject to service tax. Full stop. Any attempt to levy service tax would amount to double taxation. Full stop. There is no escapement of tax. Full stop. There would be duality of same tax. Full stop. Transaction in money within bracket relatable to the so cause notices for the period after the negative list was introduced, bracket close, is not liable to service tax was the contention. Full stop. There is provision of service only in the first leg of the transaction, where in the acquiring bank pays the merchant establishment after deducting the merchant discount, comma, which is subjected to tax. Full stop. The subsequent transaction is purely transaction in money, and there is no interse provision of service between the parties. Full stop. The so cause notices were alleged to be barred by limitation. Full stop. There is no deliberate intention on the part of the assessee to not disclose the correct information. Full stop.